Once I have enough information about that particular situation, I like to think that I can read it. But even then, it's really to ask better questions. It's not to predict the future.
Did you plan for this, or did you miss? When life demands answers you can't dismiss, will you be ready when the trumpet blows? Do you have the blueprint for life's unknowns?
Ron, from time to time, people ask me questions that I just do the best I can. There may not be a way for me to know every legal possibility. Let's keep in mind, I'm not a lawyer, right? I've been an effective private trustee and executor for more than 20 years. I've seen a lot, but I couldn't ever say that I've seen everything.
You haven't seen everything, but you pretty much know how things are going to play out.
Once I have enough information about that particular situation, I like to think that I can read it. But even then, it's really to ask better questions. It's not to predict the future, right? Because that's really what is at stake here. And this particular story is an interesting thing, kind of about planting seeds for the future and not knowing what the results will be. So I'm going to read this out loud.
Read between the lines.
Brian, 59, successfully retired early from a lifelong career selling agricultural equipment. In the early days, when sales were low, he would supplement his income by donating blood and plasma for money. When those were insufficient, Brian sold his semen to a fertility clinic. He regrets this, saying that he's never wanted children of his own due to a family history of illness. Now that Brian has retired, he's concerned about potential children seeking him out. He requested that the donation be kept anonymous, but heard that specific facility had recently experienced an information leak when a hacker accessed their files. Brian has not yet told his girlfriend, Maria, who's 48, but plans to if necessary. He intends to marry her and eventually leave her everything. What do you think about this one?
Ooh-wee, there are so many. I mean, first of all, Maria, he intends to marry her. I always love that when the intention is there, but they never act. I mean, he's 59.
He's 59 and she's 48.
What is he? Anyway. And again, understand maybe economic reasons. I mean, I'm not. But anyway, what steps should Brian take to prevent those unexpected children from contesting the will?
I would get thee to a lawyer like yesterday, because Brian has some interesting issues here. I don't know what state he's in. I don't know what state law might be applicable to making such a donation. It's possible that in the paperwork, when you made the donation, that there may be some legal way to remove yourself as a legal participant in the life that you're creating. And I know we're getting into, fertility issues and other things. Okay, so this is not a political discussion as much as it's just a practical one. If someone showed up at Brian's door
and said, "You're my dad."
Right. And we don't know when he stopped making these particular donations. So let's say for the moment, he stopped when he was 41. So the youngest person
is now legal age
could be 18 years old, let's say. But there might be minor children. I don't know how long the stuff stays frozen and how long it's viable. And so I don't want to discourage anyone from making these donations, but I do want you to think about the implications of what could happen. There was a story, and I don't have the doctor's name, but apparently he did his own donations for a long time and has dozens and dozens of children. And the people he was working with didn't know it was his sperm they were using.
Oh.
There's lots of stories like this out there. So let's think for a moment. Let's say someone does show up at the door. Does Brian have any legal obligation to make that person his beneficiary?
Or can they contest?
Well, let's start with the beneficiary part. I'll tell you why. At least in California, and I know this is true for several other states, there are two different classes of people that receive inheritance. There are heirs at law. So now you and I are blood related, Ron. You're my brother, okay? And so in that scenario, if there's no one else or any of the other people I named as beneficiaries, nobody else shows up, it may be you. And a probate court is going to look for consanguinity, right? That's whoever's blood related to you. There's a sanguinity chart. I hope I'm saying it right. So, sanguine being of blood, right? That your blood relatives would have some say. However, you may also have beneficiaries, people that you purposefully put into your documents who will inherit from you. You are their benefactor, right? They are the beneficiaries. And so heirs at law comes into play in probate. Generally, when you proactively choose, you plan ahead, you write your estate plan, you could, and again, this is not legal advice, I really want you to check this with your attorney, but you could say in your estate planning documents, I did this, I made donations and so on, without any intention ever of having any of these people be my beneficiaries. And I doubt that they'd be my heirs at law because of the circumstance under which someone would utilize this material and make babies. They're the ones responsible for the child, not me. I don't know. But I think it's worth asking the attorney.
Can it be? I mean, again, so many people come up to me and say, Ron, if I have the trust, then it's set. I mean, nobody can argue that. And all we hear constantly how people contest the trust.
Sure. Lawyers get paid to be creative. Okay. And a lot of laws were written by who?
The
Lawyers. Right. So there's always room for interpretation. There's always room for explaining. And our courts are active. Our legislators are active making new laws. Laws happen sometimes because problems need to be solved. Oh, well, we didn't know there'd be this result from this law. So now we have another law to deal with the first law. You get it, right?
The compensation of the compensate the compensation.
So you can order a copy of the California Probate Code, and the book is like this thick, for good reason. There's a lot in there, but it doesn't and can't possibly cover every single human foible and possibility.
Well, let's take Brian. Let's say he doesn't have a will or a trust.
Yes.
Like you said, and he's not married. What's her
Maria.
He's not
his intended.
His intended. So he's not married. He has no will and trust. So he would die intestate.
That's right? Correct. He would die intestate.
So wouldn't the court go and try to find a blood relative?
Right. And then we end up with finding out that Brian has potentially
10 blood relatives.
Or hundreds.
Well, God forbid. Brian, dude, let's chat.
So I think that to process this, to really think about it, right? We want Brian to go ahead and get his estate plan done now. He has an intended person. If he dies intestate and has nothing, then a court will have to decide what's to be done. And will, by that time, any of his progeny find him or connect with him? And he may not have very much. It costs money to bring a lawsuit. It costs money to contest. And should he get the trust and have it possibly contested? Or should he just stay silent and not have anything? In my opinion, he should really get the plan done. The plan is for so much more than after he dies. It's before he dies. For instance, he really trusts Maria. He loves her. Let's say he's very sincere in his intention. A lot of what happens between adults can be solved in an estate plan, meaning he owns the condo, she doesn't. He dies first. Where does Maria live? That would be one of those important things to deal with that he and Maria can talk about, and they can have a mutually supportive estate plan. And if they do get married, then they can update it because estate planning really favors the married. So it does make sense. And then he can deal with this issue. Being honest with Maria would be good.
What should he specifically be thinking about in terms of Maria? Let's give the facts that he has some wealth. And there's a possibility he could go and say, Maria, we're going to purchase this home in your name so that if I get attacked, so that's a bad choice of words, but if I get sued or if I get contested in terms of my unknown children, that this home is over here in a separate trust in Maria's name only?
I really want to say that's a lawyer question.
Okay.
It's a good question, and it's possible that that would be a strategy. However, there's not just the trust, it's also the will, the power of attorney for finance, and the advanced healthcare directive. So I want to look at this a little more holistically. In this story, he has not yet told her about his past activities.
And it says if necessary.
Right. What would make that necessary to Brian? That someone has knocked on his door? Is he laying low? Is he keeping his life small so that he has less to lose? I mean, there's stuff going on psychologically for Brian in this, where he's keeping his life under wraps. He has found someone he wants to spend his life with. He doesn't want children of his own. He just did this for the money.
And there's an interesting line in there, Marguerite, due to a family history of illness. Does he have an obligation? Like, is there something in his heredity that he should disclose?
I certainly hope he was at least honest with whatever firm he was sharing his material with, whether that be his plasma, his platelets, or his semen. Right? It's like, did you tell them that you have the family history? Because I'm sure that they have a long questionnaire and they ask all those questions. Right? Check the box. If you have heart issues or if your parents did. And so, I mean, I'm sure they're asking those questions. So I hope Brian is an honest man. I hope he was honest on those questionnaires and so on. Maybe the place decided to dispose of his material because once they lined it up with the material and his questionnaire, who wants to have that, right? And maybe it's more important that for some people that he had blue eyes and brown hair. I don't know. But I do know that by not telling Maria about this and then saying in the same breath that you want to marry her, let's get this straight, okay? Marriage is a partnership. Marriage is the business of romance. You can have romance, have it with whomever you like, as many people as you like. But once you get married, this is your business partner for life. And this person is going to be completely affected by your past choices, your current choices, and certainly your future ones.
So again, I know we're not lawyers.
No.
If he were to pass and leave everything to Maria, and they're not married, well, okay, let's say they're still not married, she gets everything. Do you see any grounds that these unknown children could contest?
I think it'd be a really uphill battle. I think that it would be a stretch because he never took financial responsibility. He clearly doesn't know who they are or how it happened. But we know this. Like, we're the audience watching the show and we have this secret. We know this, but we don't know what the donation place has told anyone. And in my limited understanding of how this works or how adoption works and so on, there are some lines between, granting this material, having that life begin, and then your financial responsibility for that future of that person.
If he were to somehow meet a child and decide to put some money towards that child in his trust or as a beneficiary, then he's really opening himself up. Again, I'm not playing lawyer. I'm just saying it would seem to me that he opens himself up to possible issues.
Sure, that's possible. But I think the most important thing right now is Maria and his relationship with her. Because there's a phantom, there's a maybe in this other stuff. And this is the person he says he intends to marry. But you got to come clean. You got to come clean when you partner with somebody.
So is this a situation where you could see the Brian and Maria family trust, the Brian trust, and the Maria trust?
Potentially, that would make a lot of sense, right? That Maria has her own separate property. She's 48 years old. I'm going to assume here that she's somewhat accomplished and beautiful and smart, and she has her own stuff. And she might have a child, maybe not.
Yeah, with that,
right?
yeah.
So we don't know that in this particular scenario, but let's say for a moment that she also has her own parents and she has her own obligations. So by having her own trust, that makes a lot of sense. She doesn't have to make Brian the trustee of her trust. He could be a beneficiary of her trust. She could be a beneficiary of his. And they could go to the lawyer together to talk about what is separate and what is together.
Would the lawyer work with both of them in this capacity? Could he or could he, she?
Well, it's a great question. Typically, with a prenuptial agreement, each has their own attorney. When a married couple goes to an attorney, they typically both utilize the same attorney to create one trust. It is possible that there'll be a blend or a combination of those things. Maria might take a document prepared by their mutual attorney and then have it reviewed, an independent review done by another attorney so that she's sure her needs are being met. And same for Brian.
And again, for Brian, you want a successful marriage late in life. Empower Maria and empower yourself and just come clean.
Oh, come clean. I mean, this could be a delicate matter for the future. And can you imagine Brian's mindset? Anytime the door rings, anytime the phone rings, I mean, oh my gosh, is he like on eggshells all the time worrying about this? Maybe he doesn't have to. The laws in his state may totally support a donation being just a donation. And if you don't know, you're living with worry and you're using your imagination in the wrong way. Really, getting these questions answered means that you can relax and live your life.
So, Marguerite, final words for Brian and Maria?
Come clean.
There's a lot of innuendo there. I'm going to leave it at that and just like and subscribe to Plan for This, and you'll get more of this insightful information on coming clean.
Independent Trustee Alliance is a proud nonprofit sponsor of Plan for This. If you are considering serving as a trustee, please visit trusteealliance.com to learn more about this complex and sometimes overwhelming job. trusteealliance.com. Plan for This thanks the Estate Sale Warehouse for all their amazing service and support. Entire home cleanouts, inventory, appraisal, auctions, sale of fine art and classic cars. Learn more at estatesalewarehouse.com.
Marguerite, we have a PlanFan question for you to address. So it says, hi, M&R. My family has rented the same home from a nice old man for as long as I can remember. I grew up in the house, and so did my kids, and so will their kids, I hope. Unfortunately, the owner passed away. What do I do next?
Well, one, I think it'd be really important to find out who owns the house now, because hopefully that gentleman had an estate plan. But even if he didn't, somehow, and depending on the state that he's in, that property can't just be held by a dead person. It doesn't work like that. And the dead don't really have rights, and they don't have a way to defend those rights. So you might have a lease that you have in place. You may want to review that lease and take a look at it. Just having paid the rent may not give you enough standing. And again, this is not from an attorney, but there are real estate attorneys. And I would suggest talking to one about your tenant rights. And you can express a desire to stay there. But usually when someone needs to wrap up an estate, they're going to sell all the property to divide in cash whatever's left to whomever's entitled to it. And just because you're a second or third generation renter doesn't really grant you any rights to the property.
Yeah, obviously this is something that I come across frequently in my situation. So given that the landlord was an older man, he may have finally taken on a property management company to collect rents and to address the property. So if there's a property management company, that would be obviously somebody to get in contact to. And who is inheriting, who's the beneficiary of the property? Is it a spouse? Is it the old man's children and grandchildren? And what is their intent to do with that property?
Right. Like, for instance, it may be possible that the family would be willing to sell to this renter, but it's probably not going to be free.
Never free.
No. And I want to make the suggestion that if you are renting a home, anywhere you're renting a home, get your hands on your lease. A lot of people lose it. A lot of people don't have it handy. And even if you do your estate plan, even though you're renting, it's a good idea for your lease to be presented to your estate planning attorney. Why? Because if you couldn't pay the rent, somebody else has to take care of that. Whoever your person is needs to know what your obligations are. And they also need to know what your story is. Like, for instance, a lot of leases have an automatic increase in them, as an example. Your auto pay is going to pay that fixed monthly amount every month, and then it goes up. Well, you have to probably go into your bank online and change the numbers so that they're correct. Well, someone will have to do that if you can't do that.
And I will say, we're recording this in San Diego County, where rents are a significant part of one's income. We see rents $8, $9, $10, $11, $12,000 a month is not uncommon to rent a single home in San Diego County. So it's a major part of one's estate is that rental payment.
Right, as on the receiving end, you're talking about from the landlord's point of view.
Well, both. I mean,
right?
If I'm writing checks to somebody for $12,000 a month to rent a home, I want to make sure that if something would happen to me, that my children can, my wife and my spouse and children can stay in that home.
Right. Well, with being in a renter position, you may not have that kind of control to be able to have your children rent the same property.
Right.
There may have been those kinds of relationships back in the day. Currently, maybe not so much. So I think talking to a real estate attorney would be very helpful. And I also think that you need to have your own plan and you need to have your own person know exactly what your obligations are so those can be met if you can't do it yourself.
Well, thank you for the question. I hope we gave you some insights of what to do next. And congratulations for living in one home for a long time. It's impressive.
Generations is beautiful.
Generations.
Beautiful.
I hope you can buy it.
Yeah, me too. Me too. Thanks, Ron. Thanks.
Money management and legacy. Will you be ready for life?